Hello everyone, welcome back to my lecture series on Hindu law. And so far we discussed about Hindu Marriage Act 1955. In this video we will discuss Dowry Prohibition Act of 1961. My entire series on Hindu law is based on the textbook titled Hindu Law written by Dr. Rakesh Ainapur, which you can purchase from Amazon, Flipkart and Vision Bookstore, and you can also download from Google Play Store and Amazon Kindle. As I told earlier, we have discussed all about marriage and kinship, how the family structure in Indian context, Hindu Marriage Act, matrimonial remedies, maintenance and alimony under Hindu Marriage Act. All these points we discussed in earlier videos. In this video, focus is on dowry prohibition as per Dowry Prohibition Act of 1961. Let's Dowry has been a long-standing social issue in many parts of India, or whole of India. We can say that, in spite of having a lot of legal provisions, legal efforts to curb it, but it is still prevailing in India. What is dowry? The basic question here: the dowry is nothing but transfer of parental property, wealth, or gifts to the groom and his family as a condition of a marriage. Okay. As a condition of a marriage, if any property, wealth, or gift is given to a groom or groom's family, is called as a dowry. There are many instances, many court cases have been happened, and there is a long-standing effort from the government side also to curb the dowry. Dowry can take form of any of the following, like gift giving. It is a custom practice that bride's family gives gift, jewelry and valuables to a bride at the time of marriage, very expensive jewelries, property or a land transfer to a groom's family, cash transactions, and any other social expectations. All these are the forms of various forms of dowry which are prevailing in Indian weddings. Here are let's see some legislative provisions of Dowry Prohibition Act of 1961. Section 1 gives the title, and this is applicable to whole of India. After abolition of Article 370, this is not required now. And then definition of dowry, as we discussed, it is a gift, property transfer, or any valuables given by one parent to other parent during the marriage, but it excludes dower or a meher, which is paid in a Muslim's marriages, which will be a part of Muslim personal law. That is where Shariat law is going to be applied. So section 3 talks about penalty for giving or taking a dowry. It is applicable for both the person who is giving dowry and taking dowry. It will be like a punishable offense with the imprisonment for not less than 5 years and with a fine of 15,000 rupees. Okay. It is a punishable offense. Even giving or taking a dowry is a punishable offense. This was dealt in the case of Kariya Perumal versus State of Tamil Nadu. The accused was charged with demanding a dowry from the bride's family. The court upheld the conviction, emphasizing the seriousness of dowry-related offences and the need for strict enforcement of the law. Right? So dowry is completely, like, demanding dowry is a false, but even giving dowry is also a offense under Indian Dowry Prohibition Act of 1961. Penalty for demanding dowry, this is the same if it is a taking, we have seen here, if any person demands the dowry but not taking it, then it will be an imprisonment for not less than 6 months, and it can be extendable up to 2 years with a fine of rupees 10,000 up to 10,000 rupees. So it is taking dowry where a punishment is 5 years. If just demanding a dowry, then it is 6 months to 2 years of imprisonment and 10,000 rupees of fine. Section 5 clearly says that any agreement for giving or taking a dowry will be void. It is a void. No agreement should be made for giving or taking a dowry. Any agreement made will be considered as void. Any dowry received that should be used for wife or a wife's then next legal years, it should not be used by husband or husband's family. Any dowry given that should be used by wife, used for the benefit of wife or wife's heirs. Failure to transfer the property to a wife or a wife's heir is a punishable offence, again in the section 6 of Dowry Prohibition Act. So section 7 deals with cognizance of offence. No court lesser than or inferior to metropolitan magistrate or judicial magistrate of the first class cannot try any offence under this act. So minimum metropolitan magistrate or a judicial magistrate of first class can try the cases on dowry. Lesser than that or inferior to these courts should not be taking any cases on dowry. And then there must be a police complaint from an agreed person, parent or a relative for taking the court taking a court actions on dowry related issues. And these courts, the judicial metropolitan magistrate or a judicial magistrate of first class, can impose any sentences on dowry related cases. Section 8 clearly states that the dowry related offences are non-bailable and non-compoundable, providing legal parameters for investigation, arrest and prosecution. Okay, any cases have lodged on the case of a dowry related matter, so then any arrest will be done in this case will be a non-bailable and non-compoundable, and there will be a process of investigation, arrest and prosecution. Burden of proof, section 8A deals with the burden of proof. It is a responsibility of a person who is giving a case, right, who is aggrieved party. He has to prove that they are demanding a dowry under as per section 3 or section 4, and then the accused can give that he is innocent, he can prove for his innocence. Okay, so initially the burden of proof should be given by bride side that they are asking for a dowry or they have taken a dowry under section 3 or demanding for a dowry under section 4, and then it is a groom side, they have to prove their innocence in such cases. There are a lot of misuse of this clause happened, and there are instances where grooms have proved their innocence, and then it has become a serious issue. We will discuss about that topic in a later part of this video. And state government can this act empowers state government to appoint a dowry prohibition officer who can take care of the affairs of dowry prohibition in the state. And section 9 grants power to central government to make any rules related to a Dowry Prohibition Act of 1961, and that will be used across all the jurisdictions in country. And even section 10 allows empowers the state government also to make rules which are specific to the state. Not only Dowry Prohibition Act 1961 deals with the dowry related cases, even Indian Penal Code earlier and now Bharatiya Nyaya Samhita, which is also have a clauses for dowry related cases. Okay, under Bharatiya Nyaya Samhita now it is section 80. Earlier it was in IPC, which is clearly says that a presumption of dowry death in case any woman passes away within 7 years of the marriage. Okay, within 7 years of the marriage, then the first assumption that court will make is it is a dowry related harassment and cruelty by spouse or in-laws and their family. So it will be considered as dowry related death, and then further investigation will be carried out. Though the intention of introducing Dowry Prohibition Act was to protect the bride and bride's family, but there are a lot of instances where the misuse of Dowry Prohibition Act of 1961 done in India. There is a false allegations of a dowry harassment, demand for something like it is more than asking for a more maintenance or a alimony, and it is a threatening coercion. All these things are happening in the name of false dowry harassment cases. There are two important case laws on that. One is Arnesh Kumar versus State of Bihar, where Supreme Court of India expressed concern over the rampant misuse of Section 498A of Indian Penal Code and observed that the arrest of the accused in dowry cases should not be made automatically. See, earlier, any case was filed, arrest was an immediate action, but in the 2014 case, it was clearly stated that arrest cannot be made automatically. There must be a proper investigation to be done, and then the arrest can be taken care. So this was the case on Dowry Prohibition Act 1961. And then Sunita Sharma versus Union of India, where the learned person Sunita Sharma, petitioner Sunita Sharma, argued for the protection of innocent persons from false dowry harassment cases and advocated for the implementation of safeguard to prevent misuse of the law. So there are numerous incidents. The intention of the law is good, but the misuse is also happening in summary. Okay guys, that's it from me on Dowry Prohibition of 1961. Thank you so much. I request you to subscribe my channel and share it with your friends. If you have any questions on this, you can put your questions in comment box. I will be happy to answer those questions. Thank you so much. Your valuable feedback is appreciated.